webinar. Like Tiffany said, we'll give everyone a couple of minutes to settle in and then we'll get started, okay? Thank you for your patience. Okay, we'll give it one more minute just to make sure everybody is settled in. Okay, good afternoon once again. Thank you for joining us today. My name, my name is Christina Delgado. I'm with the Department of Consumer and Business Affairs Mediation Program. The title of our webinar today is Facilitative Mediation. We will discuss the different styles, the mediation styles, the benefits of facilitative mediation, and the role of the mediator during this process. Next slide, please. We understand that you are joining us today, possibly sacrificing your lunch because you would like to know more about this mediation process. That is why we want you to get the most out of this webinar. At the end of the presentation, there is going to be a Q&A session. So if any time during the presentation you have a question, please use the chat feature to type in any questions you may have, and we will answer them at the end of the presentation. You can locate the chat feature by clicking the chat icon at the bottom right-hand side of your screen. The chat icon should reflect the image that you are seeing on your screen right now. Next slide, please. Okay, it is very important to us, the mediation team, to provide you with information that is important to you, and they may help you resolve a dispute you may have. That is why we would appreciate it if you could complete a short survey that will you would have access to once the presentation concludes. This survey will allow us to know how we did during the presentation and also what topics you are interested in, and hopefully we can organize webinars with topics that interest you. You do not need to select or click anything. A window will automatically pop up once the presentation and the Q&A session concludes. Also, please be aware that your microphone will not work during the session. That is why all questions will have to be asked through the WebEx chat. This webinar will be recorded and will be available on our DCB website, which Tani already posted in the chat. You could find previous recordings there and other topics. We encourage you to check them out. We will post also our YouTube link in the chat momentarily. But now I would like to introduce you to your presenter, Tiffany Martin. Tiffany?
Thank you, Christina. That was a wonderful opening. Good afternoon, everybody. My name is Tiffany. I'm the mediator with Los Angeles County Department Consumer Business Affairs Dispute Resolution Program. Again, like Christina said, I'd like to welcome you and thank you. I know you guys have sacrificed your lunch today, and you guys have many things you could be doing on lunch, and you're here with us, joining us to learn about our facilitative mediation style. Now, and again, I sincerely appreciate everything and you guys joining us. We are going to talk about the mediation, our mediation program and the style we use in our mediation proceedings. In today's webinars, I'll discuss mediation styles that we use after all parties agree to participate in mediation and mediation commences. We utilize a facilitative mediation style, which is one of the most popular styles that is widely used throughout the mediation community. There are a few different styles, which I'll briefly describe and talk about so you know and have a better understanding of the various mediation styles that are out there. And when I say briefly talk about, that's exactly what I mean, because we don't engage in these other styles, so there's not much information that I can provide you other than the description. Now let's talk about the different mediation styles that are used during mediation proceedings. The most popular mediation styles are facilitative, evaluative, and transformative mediation. I will briefly talk about each of these styles of mediation, and then I'll go into depth about the facilitative mediation style. Excuse me. Briefly go into depth about the facilitative mediation style, which again is the style that we use in our department. I will also talk about the mediator's role as a facilitator and the facilitated mediation proceedings. First, with facilitative mediation, which is this, again, a style we use. This is where a trained mediator attempts to facilitate negotiations between two or more parties that are in a conflict or a dispute. In facilitative mediation, the mediator will not make any recommendations or be making any decisions. Instead, mediators empowers and encourages the parties to reach their own solution voluntarily by exploring each party's deeper interests and concerns. In facilitative mediation, mediators are impartial and will not convey their opinion to the parties. The mediator will help set the agenda to make sure the parties stay on track and discuss the agenda items. In evaluative mediation, this is when the mediator makes recommendations and suggestions, which is in direct contrast to our facilitative mediation style. The mediator in evaluative mediation will also give their opinion. In evaluative mediation, the mediator may bring up contracts or laws or help parties with their arguments and help make determinations based on fairness and or from a legal standpoint. The mediator may even point out the weaknesses of one party's case or try to predict what a judge or jury may decide. Not always, but evaluative mediators are oftentimes attorneys who have legal expertise in the dispute subject matter, so they can make the appropriate recommendations. Evaluative mediation is also most often done in caucus, where the parties speak to the mediator separately and in private. Now, transformative mediation, this is the newest style of mediation, and it's like facilitative mediation, where the mediator empowers and encourages the parties to come up with their own agreement. But in transformative mediation, the mediator will focus on the parties' relationship with one another. The process is to transform the parties' relationship by giving the parties the skills needed to make constructive change. In transformative mediation, the mediator will allow the parties to lead and allow them to structure the process. Again, this is kind of similar to facilitative mediation, but in facilitative mediation, the mediator manages the proceedings and will help parties create an agenda to form the structure of the mediation. Next slide, please. Now let's talk about the benefits of mediation and how it can help with disputes. Our department has been using facilitative mediation style since the conception of our dispute resolution program. This mediation style has many benefits that can help parties in a dispute because because it may be more economical, it's less time consuming, and empowers parties and helps parties understand and be understood. The facilitative style combines the art and science of finding resolutions to a dispute with the help of a professional trained mediator who remains neutral throughout the process. Mediators help parties focus on a mutual resolution that best meets their interests and needs. Facilitative mediation supports non-adversarial approaches unlike lawsuits or court proceedings. It helps all parties understand the issue better by getting to the root of the problem, with the mediators assisting the parties with communicating along the way. When parties first start mediation, each party only knows their side, what they want, how they've suffered, how this dispute has affected them personally. They don't always know about the other party's interests or concerns, or how the dispute has affected the other party, or why the other party has even acted a certain way when dealing with the dispute. Helping the parties understand the dispute, and I do mean really understand the dispute from both sides, will help the parties in the dispute start to be more objective and help move the mediation forward and closer to a resolution. Facilitative mediation can help parties create solutions that are specifically geared towards each party's needs. For example, a dispute between a business and a consumer could have resulted in the consumer posting a negative online review for the business, and the party representing the business may agree to refund the money, even if they don't believe they owe it, but they want the negative review removed, so they'll agree to pay. So this review could be causing the business more harm than the refund that the consumer is asking to be returned. This type of agreement is geared towards the needs of both parties. With facilitative them in control throughout the mediation process, so they are able to explore their own resolution without having an outside third party or agency make the decision for them. If parties were to sue, they go to court, they present their case to the judge, and so, for example, in a small claims case, and the judge or the commissioner would decide the outcome. Once a party has a judgment, they normally are not in a hurry to pay after after it's already impacted their credit and it's there. So they're not normally in a hurry to pay. In mediation, sometimes you get paid a little bit faster than you would in a court proceeding. When parties create their own resolution, studies have shown that they are more likely to follow through with their commitment that they've committed to in the agreement, because that's what they came up with. So they created their own agreement, so they're going to commit to it, instead of a decision that's imposed by the judicial system. Now, mediation promotes ownership of what the parties decided and agreed on. Mediation is also confidential and gives the parties peace of mind knowing what is discussed in mediation, and the outcome of mediation will not become public record and will not be shared publicly by either party. Mediation can also be less time consuming. You can join mediation proceedings from the comfort of your own home. And with our mediation services, we offer our online dispute resolution, or I may refer to it as ODR services. And this is where you can log into your case online at any time and communicate with the mediator or the other party. You can upload documents. This service is especially beneficial to working professionals, students, or busy parents who don't have a lot of time to spare during their busy work or school week. The entire mediation process can be handled mediation process can be handled by calling one party on the phone and chatting with the other party through our ODR system. So ODR does make mediation very convenient and very accommodating for all lifestyles. Mediation also helps parties avoid that win-lose or lose-lose outcome. Parties who may have won a lawsuit may think back to all the time, the energy, the money, everything spent on this case to get prepared to appear at court, miss a day at work, and then realize the huge cost and loss, and it just wasn't worth all the time and effort spent trying to pursue this matter in court. Parties who lose in litigation, of course, will certainly feel worse because now, again, they have this judgment that's been awarded to the other party and that says they must pay, and this is impacting them negatively, especially on their credit. Now, mediation spares the parties these thoughts and feelings and allows them to move on from the dispute effectively and efficiently. Overall, facilitative mediation is less traumatic, non-adversarial, less expensive, and time-consuming, and an effective way to reach an equitable resolution. Next slide, please. Now, the role of the mediator, which we'll discuss now, in facilitative mediation, the mediator is a facilitator and is neutral and will not decide the outcome. Oftentimes, the parties think the mediator will be the deciding factor in their dispute and think the mediator will review all their evidence and then will decide who's right or wrong in the dispute. That's not how it works with mediation. And that's what litigation is for. The mediator will not give any legal advice or make any suggestions, but will act as a facilitator by helping the parties communicate and helping them progress in the right direction towards a better understanding of the dispute. And the reason why we talk about the importance of a better understanding is because once the parties have a better understanding, that is when the parties can transition from talking about the dispute and getting to the root of the problem, then moving forward to talking about resolving the dispute. Even though the mediator is in charge of the proceedings, the mediator is not in charge of the outcome and has no power to enforce a settlement on the parties. So the mediator cannot make the parties settle. The mediator helps the parties stay focused and on the topics that need to be discussed from the agenda that was created at the beginning of the mediation proceedings. Sometimes parties will discuss unrelated information that does not affect the dispute that brought them to mediation. The mediator will also help the parties express their points of views or concerns in the dispute to the other party. The mediator encourages the parties to express their feelings so that the other party understands how the dispute has affected them. Sometimes people don't understand how their words or their actions affect others in mediation, they get to see this or hear this depending on the setting because we offer both video and phone. This is why mediation promotes communications between parties to help them understand where each side is coming from. The mediator will help parties find workable solutions or a solution without placing blame or judgment on any of the parties involved in the dispute. The mediator levels the playing field so that the parties involved feel empowered during the proceedings. Empowering the parties is important, and this is part of mediation because empowerment represents a newfound confidence, strength, and represents an individual's growth during mediation. And it also leads to self-determination, which makes the parties feel that the mediation proceedings were more legit and well worth their time spent discussing the dispute. Now, power dynamics is always part of mediation. You will always have someone who is more educated, richer, has more experience in the area. Mediation provides a platform for everyone. You can have people from different backgrounds and regardless of their education level or financial status, each party will have the opportunity to speak and tell their story and be heard by the other party. The mediator will encourage the parties to talk to each other and discuss the issue and try to get to the root of the problem. In a successful mediation, the mediator should not be doing most of the talking. Instead, the parties should be doing most of the talking, and the mediator will encourage the parties to talk directly to each other and communicate their interests and concerns. Once communications have started to move in the right directions, meaning the parties have got their points of views out, emotions have settled, and the parties are now thinking more objectively, the mediator can help the parties move to negotiations. In negotiation, the mediator will help the parties discuss and try to reach a mutually acceptable agreement that's attainable. And I said attainable on purpose because we want to create solutions that are just not solutions because we want to close the case and be done and want the parties to be done. We want it to be where it's the agreement is made and the parties involved in the agreement are able to follow through with their commitment in the agreement. For example, if one party stated in the beginning of the mediation that they're not working at the time. They can't afford a lump sum, but then the mediator sees that they may be getting a little exhausted and they just agree to this lump sum payment in the next couple of days. This may be an agreement that's not attainable, and this may result in a settlement agreement being breached. The mediator will help the parties get creative and find solutions that can be geared towards their needs. With facilitative mediation, it keeps the control in the hands of the parties instead of outside individuals or authorities, meaning the parties get to decide their own outcome. In litigation, the parties present their cases to a third party, normally a judge or commissioner. That third party will determine the final decision. In mediation, this is not the case. The parties can explore resolutions that fit their needs. For example, let's just say there's a dispute where one party owes the other party money, and it was a car accident. The other party that owes, he just flat out says, I haven't been working, I can't, I don't have the money to pay. But this other party may have some type of skill that's beneficial to the other party. For example, he could have a landscaping business, or he can be a general contractor, and maybe he can offer his services in replacement of an actual payment to the other party. And we've had cases that settle this way, so this is not uncommon. So as you can see with mediation, settlements can get very creative. Next slide, please. Now, throughout the facilitative mediation proceedings, the parties can expect to be in a non-adversarial environment. Parties can expect to be in control of the outcome and can expect to come out of the mediation with a better understanding of the dispute. Parties should come to mediation ready to listen with an open mind and ready to discuss the details of the mediation, of the dispute that brought them to mediation. Throughout the mediation proceedings, the party should expect to do a lot of talking. Again, the mediator will provide each party with a platform so they will be able to tell their story. If the mediator senses either party is having trouble communicating their side, then the mediator will help with a quick open-ended question to get the conversation moving again. During the proceedings, the mediator will give the floor to the parties and stay in the background and listen while the parties are speaking and discussing the dispute. The mediator definitely will chime in when needed to help the parties stay on track or just to keep the conversation or communications moving in a positive direction. The mediator may interrupt the conversation to ask clarifying questions to get the party speaking, that's speaking to elaborate more on a topic or to better explain an event or an occurrence related to the dispute. When parties give vague statements or go off topic, the mediator will help the party with the who, what, where, when, and how questions. So, who did you speak to? What was your understanding of the refund policy? Where did the conversation take place? What was the response that the supervisor gave you? So simple questions like this is what can help keep the communications flowing between parties. During proceedings, the mediator can choose to caucus if they feel the need to speak with the parties privately. And caucus just means speaking to the parties privately. The mediator may sense that one party is hesitant with giving details related to the dispute or just having trouble communicating their side of the story. The parties can also ask to speak to the mediator privately, and the mediator will caucus at that point. The mediator will speak to both parties in caucus, giving each party the same opportunity so that one party does not feel like that the other has gotten special attention. As the proceedings start to move into the negotiation phase, the mediator will help the parties along to think outside the box and get creative. And this is what mediation is. And the parties can agree on what they choose and settle how they want. In mediation, it doesn't matter what a contract says, what a law says. If the parties agree to an amount that's something other than what a law says, then that's okay because they are both agreeing. That's why it's called a mutual agreement or mutually accepted agreement. And resolve doesn't always mean money was paid or services performed. It could mean the parties now understand each other's position and has decided just to end their dispute after talking about it. The mediator will determine when it is time to end the mediation proceedings, and there are a few ways mediation proceedings can end. It can end as fully resolved, partially resolved, or unresolved, but it will never end without the parties gaining a full understanding of the dispute. Mediation is a great way to resolve the dispute before proceeding with litigation. We encourage parties to try mediation and see if it's something that can help them out when they're in a when they're in a dispute. So now you know and have an idea of how our mediation proceedings are handled with the facilitative mediation style that we use. This concludes my presentation, and I want to again thank you guys for joining us today. We'll now answer some questions that have been sent in the chat, and it looks like we do have some time, so it's not too late to submit additional questions if you have any.
Okay, thank you, Tiffany, and thank you all for your questions. We will answer them momentarily. I just want to inform you that if you want to know, learn more about our mediation process, or if you want to submit a request for mediation, please visit our website at dcba.lacounty.gov /mediation, or you could give us a call at 1-800-593-8222. I'll go ahead and post that in the chat momentarily. But having said that, next slide, please.
I think this is the final slide right here, Christina.
Okay, so then we are on our now in our Q&A session. If you have any questions, please use that chat box located at the bottom right-hand side of your WebEx screen. We'll give you a few minutes to type in your questions, but in the meantime, we will answer the first question.
I do see a question, how much does the process cost? Our mediation services are offered at no charge. So the only requirement is that one of the parties has to be within LA County, our jurisdiction. So I've mediated cases where one party was here in LA County and the other party was in England. We did a lot of online and email, but it was able to be done. So there's no charge for that. Let's see. I feel like there's a note somewhere high.
Okay, so we do have another question, Tiffany. Let me go ahead and read it to you. Does the turnaround time for mediation requests to the first meeting vary? Is there a huge backlog with COVID-related hardship and financial claims?
No, not a huge backlog. The time of mediation is kind of hard to just quote directly to you. Once you submit a request to us, our processing time is about 5 to 7 days, meaning that's when we review it, look at it, and then send out the notification to the other party. The time frame I can't quote is the time frame is going to take the other party to respond, because mediation cannot begin until the other party voluntarily participates. So some people respond immediately. Some parties may take a couple of tries where we have to contact them a few times before they respond to us. So that is the only time frame I can't quote you. But a lot of times mediations can move a month, maybe 4 to 6 weeks.
Okay, thank you for your answer, Tiffany. We'll give you guys a few minutes to type in your questions if you have any. I know it might take some time to type it in.
Me to speak a little slower, so I apologize. So if the person who wanted that has any questions about anything, please put it in the chat.
Okay.
I see a question. Are there specific dispute circumstances mediation will be denied or referred out? The only mediations that we do not do are family law, because family court has their own mediation program, and any criminal activity, we won't mediate anything like that. Other than that, again, as long as one of the parties is in our jurisdiction, it can be mediated. Can the mediator point out the weakness of my claim? No. In my presentation, which I stated, the mediator is never going to point out any weaknesses, give their opinion. That's what evaluative mediation is, and that's not the style we do. So the mediator just helps you guys communicate. Again, mediation is about what you and the other party can agree on. It's not necessarily what how a judge will decide. It's what you guys want. So it's what you can live with, basically, is what you probably want to be open to when you're dealing with mediation. But no, the mediator will not point out any weaknesses to your claim.
Okay, thank you, Tiffany. We also have another question. Can you support a student that is going through the Title IV process?
Again, we can mediate. Our mediators are not specialists on any subject matter. And the reason being is because we're a facilitator and we're just here to get you to communicate your side to the other party and the other side to and the other party to communicate to the other side. So we're just a middle person there, a tool to help you guys communicate and give the information. You can come to us with all the information. If you want to present your own laws, laws that you found regarding this issue, you give that information to us, or depending on the mediation setting, whether we're in a chat or face-to-face, and you can give that information to the other party, or we'll relay that information over for you. But it's not that we specialize in any specific topic.
Thank you, Tiffany. And actually, yes, that was actually Title IX. Sorry about that.
Okay. Should I try mediation if my landlord refuses to talk to me? Absolutely. You'll be surprised when you add that third party into the dispute. We can get a lot of information out of a party, especially when communications have broken down between the two parties that's in the dispute. Because a lot of times once we get involved and we speak to the other party, they're very calm, they're professional, they talk to us, they give us the information, and that just might be the information you needed, to start moving the dispute in a direction where you guys can start trying to work out a resolution.
Okay, we'll give you guys a few more minutes just in case you guys have any additional questions.
Also, I want to tell you guys, there's no too small of an issue or too big of an issue to submit to mediation. We've had requests where refunds were as small as, $5, that didn't happen. So, if something is where if you guys can't communicate or it's not happening, you can always try mediation. There's, again, no issue that's too big or too small. Again, just no family court matters and no criminal activity, of course.
Okay. I did post our phone number just in case you guys want to call us instead of visiting our website. Once again, we do encourage you to visit our website. It does have additional information that may be helpful to you, and also you can see our other services we provide.
Okay. There's another question. Can I try mediation instead of going to court? Absolutely. But even when people call in and I counsel them on mediation, I always tell them it's a step before going to court, because again, court is time consuming. There's filing fees. You may not see a judge until about 60 to 90 days out, depending on the court calendar. So mediation is definitely a step that you would want to try to get to try and resolve the dispute prior to going to litigation, going to court.
Okay, we do have another question. I don't know if you already answered that, but I want to say it just in case. I don't want to miss a question. Are there any circumstances that require mediators to disclose information to authorities, example housing?
No, mediation is completely confidential. So we would not disclose any information to any outside agency or any outside party. And that's also one of the benefits of mediation, because court proceedings, they create public records. So anybody could go and look up like the the minute order to the court proceedings and see what happened. With mediation, everything's completely confidential.
Okay. So meanwhile, we'll give you a few more minutes to write in any type in any questions. I do want to inform you if you have any questions that were not answered during today's webinar, or if you come up with any questions, once again, please feel free to contact us by telephone or by visiting our website. Let me see. Give me one second. Yes, thank you, Tenny. So Tenny posted our link for a mediation request. That will direct you directly to our mediation request form.
Okay. I think did we answer everything? And I answered the question?
Right now, yes.
Okay, I just want to make sure.
Okay, we'll give you guys one more minute just in case you guys have any last questions. Okay, we do have another question. If I try mediation, I no longer have to go to court.
Well, that depends on the outcome of the mediation. So sometimes people will already have a pending court date. If it's a small claims case, we're able to submit stipulated agreements to the court directly. If it's like a debt collection case or a civil matter, you can still try and mediate it with our department, but then it would be up to the plaintiff to dismiss the case. We wouldn't have any involvement in that. But yes, you can, if you have a pending hearing, you can still try to mediate it to try to avoid going to court. But excuse me. Oh, and I forgot to say is the main part of the question is if you do not settle the case, then yes, you would still have to show up to court to your hearing.
Thank you, Tiffany, for that answer. Once again, we'll give you another minute. Okay, looks like that's all the questions for today. Once again, I just want to remind you again, if you have any additional questions, please visit our website or call us. I did post the information on the chat box, so did Tenny. And also want to remind you, if you could please complete the survey, it will help us and also help you. Hopefully we could better your experience in the future. Okay, thank you so much. Thank you, Tiffany.
Thank you. Have a good one.
Bye.